Thank you, Mr President. I rise on behalf of the Greens today to speak on this bill. We recognise that this particular bill is a product of many years of review and consultation. The current Training and Skills Development Act has been in operation for more than a decade, and a review of the Act did commence in 2016, but it was not concluded. Since that time, the Marshall Government has undertaken consultation through Your Say, and that was set to conclude on the 20th of August. Indeed, I note in the other place that partially the bill there was debated prior to that date. While we appreciate many of the stated goals of the government in bringing about this particular amendment bill in terms of the Training and Skills Development Act, such as a streamlining of processes and simplification, we do actually have significant concerns about some portions of this legislation, and indeed will struggle to support it at third reading without amendment. Of significant concern is the amalgamation of the functions of the South Australian Training Advocate and the Training and Skills Commission into the newly established South Australian Skills Commission. The government has stated in the other place and in briefings, which I thank them for, that the reason for this amalgamation is to provide clarity, as at present industry would struggle to know who to contact. We are assured that neither of these roles or functions of either the South Australian Training Advocate and the Training and Skills Commission are lost. However, that's not actually entirely the case. Through this amalgamation, while the functions and services remain, what we are losing is the independent voice and advocate for trainees and apprentices. That is hugely concerning. This is not the first time we have seen this government, through amalgamation of roles, remove that independent oversight in specific fields. Indeed, it seems to be forming a quite disturbing pattern. We have seen this with the public trustee and a guardian amendment bill recently, where it was planned by the Marshall Government that the public trustee and the public advocate were to be amalgamated. Again, we were told that this would be simplification, yet they had very different and critical roles. And certainly in that situation, the parliament prevailed, and the attempt to amalgamate and lose that independent oversight and that absolute integrity that was required was indeed defeated by democracy. And democracy upheld the very vital and different roles of those bodies. To a lesser extent, we've also seen this approach as part of the Healthcare Governance Amendment Bill 2019 and 2020 debates. Again, where independent oversight and advocacy bodies were sought to be removed and disempowered. Again, while I won't mention that bill too much because it is currently before this place, the previous debate saw this council uphold the roles such as that of the Health Performance Council and the Mental Health Commissioner, both of whom bodies I think worthy of the support that this council has given them. The Greens are quite concerned that employee and employer voices are not required to be represented on the South Australian Skills Commission. We do understand that the government seeks to appoint people based on a skills matrix, and they have certainly countenanced that and outlined it in the other place. However, we are not convinced that the South Australian Skills Commission is best served by being made up solely of those handpicked by the minister. To that end, it is my understanding that the opposition will be moving amendments, and those amendments would see both an employee and an employer voice, that being SA Unions and Business SA, have representatives as a member of the Commission, and the Greens will be supporting those amendments. We do have further concerns about this bill in terms of the extension of the probation periods for those undertaking traineeships. This means that we often have young and inexperienced workers who are facing great uncertainty about their training contract. While this has been amended in the other place already, we understand that some apprentices could still spend as much as 6 months of their traineeship under probation. Trainees and apprentices are already some of the most vulnerable members of our workforce. They deserve our protection, Mr President. There is already a significant power imbalance that exists between trainees and their employers. And again, that is where the Parliament can protect those most vulnerable in our workforce. On the surface, it does seem reasonable that a probationary period is extended to be as long as 25% of the total traineeship or apprenticeship period, especially as this is unlikely to affect most traineeships significantly due to their length. However, for some undertaking an apprenticeship, which can take 2 years, this means that they could be spending 6 months under probation, 6 months of uncertainty. That is not a viable proposition to put our most vulnerable workers in to sign away those current rights that they have, placing them into quite a precarious position. The Greens certainly don't think the way to achieve flexibility and to streamline and simplify should be about watering down protections for apprentices and trainees. Again, I will therefore flag that we will be supporting amendments to keep the current 60 days probationary period for a training contract that lasts less than 24 months and ensure that it is the maximum probationary period for a training contract lasting longer than 24 months is 90 days. Finally, I would like to add that the Greens do share the concerns of the Labor opposition in regards to the rather odd way in which ministerial directions are being handled under this bill. It is genuinely bizarre that under the bill, as it currently stands, any directions from the minister are to be published in an annual report. This means a direction from the minister might not be published for up to a year. The Greens don't think this is acceptable, and so we will again be supporting those Labor amendments to ensure that the directions are laid before both Houses of Parliament within 3 sitting days. I note that I will, Mr President, be seeking to move that this bill be referred for proper scrutiny. We've seen 2 stages of the Your Say consultation put out, but a bill that in fact came back before the Parliament before those consultations were concluded, that, as the Honourable Claire Scriven has raised, had 43 amendments from the government to their own bill already, and certainly has had lots of constituents similarly contact the Greens, who I don't think have been told the actual bill that we're here debating in the Legislative Council can't possibly have been told in terms of extending their quite enthusiastic support for its passage, and yet don't necessarily know the exact detail of the bill that they've been told that they are supporting. It does demand further scrutiny. Vulnerable workers and apprentices do demand our protection as a parliament, and that's why, Mr President, I move to leave out all the words. I will be moving to leave out all the words after that when we go to the second reading debate on. I'm not moving it now, I'm just flagging that I'm going to move it. I'll be moving during the second reading debate on the question at that time of the second reading vote, that I would leave out all the words after that and insert instead, the bill be withdrawn and referred to the Parliamentary Committee on Occupational Safety, Rehabilitation and Compensation for inquiry and report. That is... I'm happy to, Mr President.
Is that seconded? It's been seconded, and then I will put that question when we get to the second reading vote.
Thank you, Mr President, for your assistance. I do so because this bill deserves more scrutiny than it has been given so far. It has been put out for consultation half-baked and brought before this Parliament in a form that is not the form that we are now debating here. It is quite concerning to me as well, and I certainly ask the government to respond to this in second reading summary, as to whether the provisions in this bill leave us out of step with the Education Services for Overseas Students ESOS Act 2000 requirements legislatively in terms of that role, in terms of the training advocate. I have some concerns that we are not only leaving young, vulnerable apprentices and trainees in the lurch, but we are potentially thumbing our nose at the federal law. With that, The Greens look forward to the referral of this bill for proper consultation to a committee, and we reserve our rights, should the bill go through the committee stages, to have many more questions as it progresses, and certainly will not be supporting it without the Labor opposition amendments being supported at that third reading stage.